Your Honor.
Yes, ma'am.
Mr. Schmidt is ready. Schmidt.
Listen, hear me out. All right, Mr. Schmidt, who are you ready on?
Judge, you should have 3 sets of plea papers in your queue, and also have an amendment on an MTA for Mr. Hamilton. Are you ready? Yes, sir. Oh, come on, Dad. This is Mr. Hamilton.
All right, this is cause number CR 21-71, State of Texas versus Roy Lakeenan Hamilton. Motion to adjudicate or revoke. I see that the state has filed its motion to withdraw the state's motion to revoke, asking the court to allow them to withdraw the motion, continue Mr. Hamilton on community supervision, probation, extend his period for an additional 1 year, have him serve 148 days in the county jail as a condition of probation, for which he would receive credit for time served, and that he would be amended to include new attorney fees in the amount of $500. Mr. Hamilton, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, thank you. You can lower your hand. All right, Mr. Hamilton, you heard me read what the state is asking, indicating that that is an agreement between you and the state. Is that correct?
Yes, sir.
And Mr. Hamilton, has anyone threatened you, forced you, or pressured you to make this agreement today?
No, sir.
You're represented by your attorney, Mr. Richard Schmidt. Are you pleased with the work that he's done for you?
Yes, sir.
All right, and counsel probation department is in agreement with Mr. Hamilton's conditions of community supervision being continued and extended?
Yes, sir.
All right, court hereby grants the state's motion to withdraw, extends the period of community supervision for an additional 1 year, orders Mr. Hamilton to serve 148 days in the county jail as a condition of probation, gives him credit for dates and time served as indicated in the motion and order, and the court orders him to pay $500 as new costs associated with the filing of this motion. All right, Mr. Hamilton, you're back on probation. I hope that this 148 days has caused you to have a different mindset.
Yes, sir.
All right. Thank you, sir. We're concluded in this hearing.
Thank you, Judge.
You're welcome.
Thank you.
Yes, sir. Wait. No, you're done.
Are you done with that one?
Yeah.
Who's next?
Judge, you should have Smith, Travion Buie, and Tinsley in your queue, and in whatever order you'd like.
Okay. I'll just start at the top that I have. Tinsley, Dustin Tinsley. All right, this is cause number CR 25-125, State of Texas versus Dustin Levi Tinsley. Mr. Tinsley, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand. Your name is Dustin Levi Tinsley, is that correct?
Correct.
Mr. Tinsley, are you a United States citizen who reads, writes, and speaks English?
Yes.
Have you ever been diagnosed with a mental condition?
No.
In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with the work that he's done for you?
Yes.
Do you have any questions about any of the paperwork that you've read and signed?
No.
Mr. Schmidt, do you believe Mr. Tinsley to be competent? And if so, have you explained to him his rights regarding this case?
Yes, sir, on both counts.
All right, Mr. Tinsley, you were originally charged with a felony offense of assault of a family or household member by impeding breath or circulation. I see today that there's a plea agreement in your case wherein the state's recommending to the court that you be convicted of a lesser included offense of a Class A misdemeanor assault causes bodily injury of a family member. And their recommendation is upon conviction that you serve 188 days in the county jail, for which you will receive time served. In addition, you will be fined $1,000, responsible for court costs of $270, and reimbursement fees of $520. Mr. Tinsley, is that your understanding of the plea agreement? I'm sorry.
Yes.
Okay.
Yes.
All right. Mr. Tinsley, understanding the plea agreement and the range of punishment, this time I would ask you to plead to assault causes bodily injury of a family member.
Definitely not now. Guilty.
Yeah.
So,
Guilty.
There's a lot of noise I can't hear. You said guilty. You're pleading guilty, Mr. Tinsley?
Yes, sir.
All right. And Mr. Tinsley, has anybody threatened, forced, or pressured you to plead guilty?
No, sir.
All right. Court will accept the defendant's plea of guilt. Mr. Schmidt, any objection to the stipulation of evidence?
No objection.
That is admitted, and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Your Honor, only that state is in compliance with victim services. VIS was sent out and not returned.
Thank you, Mr. Hartwell. All right, then court's going to consider the evidence. All right, the court, having considered the evidence, finds enough evidence to convict the defendant. The court follows the plea agreement. The court convicts the defendant of Class A misdemeanor assault causes bodily injury of a family member, assesses sentence pursuant to the plea agreement at 188 days confinement in the county jail. Court awards Mr. Tinsley 188 days credit towards that sentence. Orders him to pay a fine in the amount of $1,000 and assesses court costs of $270 and reimbursement fees of $520. Mr. Tinsley, when you are released from custody, you need to report to the courthouse between 8 a.m. and 5 p.m. Monday through Friday and discuss setting up arrangements to discharge your court costs, fines, and reimbursement fees. Failure to do so could result in you being arrested for failure to pay those fines. You understand that?
Yes, sir.
All right. Mr. Tinsley, you hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm going to have you step over to be fingerprinted.
sure.
Go ahead and just bring up whoever you want next, Mr. Schmidt, while I'm signing these.
There you go. Send one down. Somebody's doing better. Exactly. In fact. 16. Yeah, it works for me, but then I just get back. I'll play the hell out of it there.
All right, this is cause number CR 24-198, State of Texas versus Keith Buie. Mr. Buie, you'll raise your right hand. I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
Thank you, sir. You can lower your hand. Mr. Buie, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with the work that he's done as your attorney?
Yes, sir.
Do you have any questions about anything that you've read and signed today in your plea agreement?
No, sir.
Mr. Schmidt, do you believe Mr. Buie to be competent to enter into this agreement? And if so, that he understands his rights according to the explanations that you've given him?
Yes, sir, I do.
All right, Mr. Buie, you are charged by indictment with a third-degree felony offense of criminal mischief that does carry a range of punishment not less than 2 years in prison, not more than 10 years in prison, and a possible fine not to exceed $10,000. I see the plea agreement in your case. Upon you pleading guilty, the state's recommending that the court consider the evidence, convict you of the offense, and assess your punishment at 4 years confinement in the Texas Department of Criminal Justice. Mr. Schmidt, how much credit time, if any, is Mr. Buie entitled to?
231 days.
So, Mr. Buie, you would receive 231 days credit towards that sentence. In addition to that, you would be assessed a fine of $1,000, court costs of $290, and reimbursement fees of $75. Mr. Buie, do you understand that plea agreement? And is that what you're asking the court to approve today?
Yes, sir.
All right, understanding the plea agreement and the range of punishment, Mr. Buie, how do you plead to criminal mischief greater than $30,000, less than $150,000?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
Mr. Buie, has anyone threatened, forced, or pressured you to plead guilty?
No, sir.
All right, court does accept the defendant's plea of guilt. Mr. Schmidt, any objection to the stipulation of evidence being admitted?
No objection.
That is admitted, and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Your Honor, only that state is in compliance with victim services. Restitution documents were sent out and were not returned.
Okay, thank you. I was going to ask about that. I appreciate it. Anything further from the defense, Mr. Schmidt?
No, sir.
All right, court is reviewing the evidence. All right, the court, having reviewed the evidence, finds enough evidence to convict the defendant of the offense. The court does follow the plea agreement. Court convicts the defendant of criminal mischief greater than $30,000, less than $150,000, assesses punishment at 4 years confinement in the Texas Department of Criminal Justice, assesses a fine in the amount of $1,000, court costs of $290, and reimbursement fees of $75. Court awards Mr. Buie 231 days credit towards his sentence for the time that he's already spent in jail on this cause. Mr. Buie, once you're released from TDC, I need you to report to the Van Zandt County Courthouse and make arrangements to pay off your fines, court costs, and fees, okay?
Yes, sir.
All right, thank you, sir. You're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence and have you step over to be fingerprinted.
Yes.
Who's next, Mr.
Casey Smith.
All right, this is cause number CR 25-172, State of Texas versus Casey Patrick Smith. Mr. Smith, you raise your right hand. I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can lower your hand. All right. Oh, I'm sorry. I guess there's two causes. This also in cause number CR 25-173. All right, Mr. Smith, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Richard Schmidt. Are you pleased with Mr. Schmidt and the work that he's done as your attorney?
Yes, sir.
Do you understand everything you've read and signed in your plea agreement?
Yes, sir.
Do you have any questions about anything?
No, sir.
Mr. Schmidt, do you believe Mr. Smith to be competent? And if so, have you explained to him his rights regarding the case, including the advantages and disadvantages of a deferred adjudication plea?
Yes, sir.
All right, Mr. Smith, you are charged by indictment with a third-degree felony offense of evading arrest or detention with a vehicle. That's in cause number CR 25-172. That does carry a range of punishment that's not less than 2 years in prison and not more than 10 years in prison, and a possible fine not to exceed $10,000. I see the plea agreement in your case is upon you pleading guilty, the state's recommending that the court consider the evidence and then asking the court to place you on 5 years deferred community supervision, asking the court to order you to pay a fine of $2,000. Hey, Mr. Schmidt, can you do me a favor and just tell, I can hear people talking, and it's hard for my
Yeah.
court.
I understand Mr. Manning is going over plea paperwork. This new
Can they move-
microphone picks it up like,
Can they move further away by chance? Or-
I think you probably have to go out.
Sorry.
the line.
Sorry, it just makes it hard. Ms.
I
Christensen,
understand, Judge. I understand. Just one second.
we might need to come up with some kind of cubicle sound barrier in there, something to help you guys.
Yes, sir. I think, are you ready?
I'm ready if y'all are.
I think we are.
Okay. All right. So the plea recommendation, Mr. Smith, is for upon your plea of guilty that the state's recommending that you be placed on 5 years deferred community supervision. They're asking the court to order you to pay a $2,000 fine, that you serve 90 days in jail as a condition of community supervision, for which you would get credit for those 90 days. The state's agreeing and asking the court to dismiss the unauthorized use of a motor vehicle as part of this agreement, along with 2 other unfiled cases, one being evading arrest or detention, and the other being a possession of controlled substance. You would also be assessed court costs of $290 and reimbursement fees of $520. Is that your understanding of the plea?
Yes, sir.
All right, Mr. Smith, at this time, how do you plead to evading arrest or detention with a vehicle?
Guilty, Your Honor.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty?
No, sir.
All right, the court does accept the defendant's plea of guilt. Mr. Schmidt, any objection to the evidence?
No, sir.
Stipulation is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
All right, anything further from the defense, Mr. Schmidt?
No, sir.
All right, court's going to review the evidence. All right, the court, having reviewed the evidence, finds enough evidence to convict the defendant of the offense. The court hereby follows the plea agreement, defers the finding of guilt, places the defendant on 5 years community supervision, assesses a $2,000 fine, $290 court cost, $520 in reimbursement. Court also orders Mr. Smith to serve 90 days in the county jail as a condition of community supervision, receiving credit for those days as indicated in the order. Further, the court does dismiss under section 1245 cause number CR 25-173 and unfiled DA causes evading arrest or detention of the vehicle and possession of a controlled substance of penalty group 2. Mr. Smith, you hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm going to have you step over to be fingerprinted. After that, you'll meet with probation.
Sir, thank you.
You're welcome.
Yeah, I have
Ms.
to.
Thank you, Mr. Schmidt. Ms. Abraham, we need to squeeze in Mr. Thompson
He's
from
up.
this morning.
He's on his way.
Thank you.
And you can just sit on your, just sit right here and then, but you can sit on your thing.
Thank you.
He has a walker that he sits on, so.
Okay. All right, let me bring in Ms. Fallhaber. All right, Ms. Fallhaber.
Yes, sir.
All right, can you see and hear me okay?
I can.
All right, are you ready for Mr. Thompson?
Yes.
All right, court calls cause number CR 25-19 and CR 25-160, State of Texas versus Cedric Earl Thompson. Court finds that Ms. Fallhaber is attorney of record for Mr. Thompson in CR 25-19, which is a possession of controlled substance, second degree felony. And we're set for pretrial in that matter. Before we take an announcement on that, let me ask Mr. Thompson, it's my understanding that you have not retained and hired Ms. Fallhaber or anyone else regarding your new charge, which is CR 25-160, which is a possession of controlled substance, second degree felony greater than 4 grams, less than 200 grams. Do you intend to hire Ms. Fallhaber to represent you on that matter, or how do you intend to proceed?
I intend to hire her, but I'm in the process of selling my house to obtain the necessary funds to hire her. And I need to be out because it's my house and I need to be out to sell it to obtain the money. And it's a fully paid off house. I've worked hard for it, Your Honor, to pay this house off. And I paid it off in this with no indulging of drugs and nothing like that. I worked for a long time as a truck driver and I paid this house off. Now it's in the process of selling.
All right, let me get an announcement from your attorney on your case that she's representing you on. Go ahead, Ms. Fallhaber.
Yes, Your Honor. I'm requesting that we reset pretrial so that it can run with the new cases. And I believe ultimately at this point for cases number 2 and now 3, he's going to need to fill out an affidavit of indigency and get a court-appointed attorney since he doesn't presently have the ability to hire. And I don't at this moment, because of the new case, one of which again is not yet indicted, have a plea offer. So I think that the most prudent move, if Your Honor would be so inclined, would be to give us a little more time to try and let the new cases get caught up and get him an attorney on those and see what we can get figured out for Mr. Thompson.
The problem is going to be is he's not indigent. If he owns real estate that he can sell and pay for an attorney, he's not going to qualify under the indigency statute. So the Van Zandt County taxpayers are not going to pick up his legal bill when he has real estate that he can sell and he's already retained you on another case. So we're going to have to come up with another plan. We can't let the indicted case that you're representing him on follow 2 cases that are going to be lagging and waiting. So what we can do is we can move forward on this case, and Mr. Thompson will have to make a decision on how he wants to handle the other 2 cases. But if he owns real estate, he's not going to be deemed indigent.
And
So
Your
he may
Honor,
have to.
and Your Honor, I appreciate where the court is coming from, of course, but I'm not quite certain how to move forward either, because I was hired for like basically pre-trial to work out a deal, which we had done until the new cases cropped up. And so I'm not sure what the state's position at this point is. But if he's going to need to move forward, for example, to trial, unless he somehow can sell his real estate from jail or bond out, I think I'm going to wind up having to be in a position to file a motion to withdraw and urge that before the court.
That's noted. That's noted. Mr. Hernandez, anything from the state? I mean, I wouldn't expect you to have anything, but in case that you do.
Your Honor, we actually had thought we might have worked out that first case, but things obviously have changed now in light of case number 2 and now case number 3. So that's really where we are at this point.
So Ms. Fallhaber, this is what I'm going to do. I'm going to reset your case for pretrial and set it for about 30 days out. Are you available on October 16th?
Let me check my calendar. I had filled out a pass slip when I was in court earlier. I think it was for a date that was a little later in October, but let me see if I could do. Right now I have a setting in Corsicana on the 16th in the morning.
What about the 14th?
I'm set in Dallas.
What about the 28th?
I am available. That is the date that I had put on the pass slip.
Okay, well, court will set Mr. Thompson in all cases on the 28th for the same thing that they're set for today. Mr. Thompson, so Ms. Fallhaber is obligated to represent you for what she's been retained, which is only one charge, second-degree felony possession. They've indicated that you have a new charge, which is CR 25-160, that you have not retained her on. And they have mentioned yet a third case, which is not before this court, at least it's not on this docket today. I don't even know if it's been indicted. So Mr. Thompson, you've got until the 28th to try to figure out what you're going to do to either come up with funds to hire Ms. Fallhaber or someone else to represent you on all your cases. And so in this time, you may try to determine how to be able to sell your real estate from where you're at, or how to post bond so that you can get out. But that's going to be on you to figure out those things. It's not the court's problem to figure out how to get you out so that you can move your real estate. But your real estate is going to be an asset that you're expected to liquidate and use for your attorney fees. Does that make
Yes, sir.
sense? And so,
Yes, it does.
were you going to say something? Go ahead. Just
Yes,
don't,
sir.
just let me warn you, don't say anything about any of your other cases. Don't say anything
No.
about the facts of your cases or anything of that nature. Go ahead.
No. You saying that no way that I can be released? Like,
I didn't say that. No, no, sir.
No,
I didn't.
No, I didn't mean it. I mean, like pretrial release. I mean, it's kind of hard to work from in here to try to do real estate deals. I mean, from my opinion, I mean, it's I myself, I don't see myself like I am as a flight risk, nothing like that. I mean, but I just need ways to get out and do this right now. I mean, I don't have any money. I mean, right now I have probably about $600. My bail bond is like $1,000. So I'm asking the court to show some kind of little leniency with me to honestly go out and sell this real estate. The house is a nice house. I mean, everything to get the money. I mean, Miss Fallhaber should. I mean, I don't know. I paid her for the first case, and I'm just having a hard time coming up with $10,000 more. I mean, that's.
I understand. And so what I'm telling you is I'm giving you until October 28th. Why don't you speak to Ms. Fallhaber? She's an attorney. She can advise you on ways to sell your real estate via power of attorney. People do that all the time. People buy and sell real estate without ever being in the state where they buy it. So being in jail and selling something outside the jail is not a legal impossibility. So that's something you need to figure out. And I'm resetting the case today so that we could try to get some kind of counsel for you on these other cases so that they can try to get you some kind of deal to dispose of all of this. And if you want to work with Ms. Fallhaber to represent you, then she needs to be paid for the services that she's going to render. Okay. So my suggestion is speak with her about that. And if you can't come up with a solution, then it's on you to figure out how you're going to handle your other two cases.
One other question. So I can bond out, is it possible? Right.
Yes, you can. Yeah, you have bail set in all your cases. So once you make bail, then yeah, you'll be out and you can do what you need to do.
All right,
And
thank you.
there's no motion to reduce bail or anything that's before the court. So there's nothing for the court to rule on in that regard. Okay.
Okay. Thank you.
All right. You're welcome. We'll see you back on the 28th. Thank you, Ms. Fallhaber.
Thank you. Is that at 1:30?
That will be at 1:30 so long as he's in custody. If he's not in custody, then it'll be at 9 a.m. So if he
Yes,
bonds
sir.
out, it'll automatically revert to 9 a.m. If he stays in custody, it'll be at 1:30.
Okay, thank you. May I be excused?
Yes, ma'am.
All right, thanks.
That's it.
Thank you.
You're welcome, sir. Mr. Manning, who are you ready on?
Judge, we can start with Mr. Mitchell.
Is that a plea, Mr. Manning?
No, Judge. This will be a
Okay.
reset.
All right, this is cause number CR 25-183. State of Texas versus Roy Mitchell III. We're set for arraignment. Go ahead.
Yes, Judge. I was appointed yesterday, and I have yet to be able to get discovery in this case. So if we could have the copy of the indictment pulled up, that way I can we can waive arraignment.
All right, I need to log on to LGS. Give me just a moment.
Thank you, Judge.
Your Honor, if you'd like, I can share my screen and pull that up.
I'm already halfway to this.
I don't know. Wisdom, right? No choice. We have a video friend we have to talk about whenever.
Mr. Harville, 1 second. Will you go ahead this way? My computer has logged up. You're at the board.
Well, then you stop and say, yeah.
So the second to be found in hands. First to be found eight. So they spiked in life. That is that on July 13th, 2025. You intentionally for good legacy laws, you again rejecting folks was intentionally arrested for detaining. Boy Mitchell the third. Your hands on paragraph is from their plea to the bringing the habitation back. Your Honor, on, I believe this CR 25-183. Yes. My client pleads not guilty. He understands the charge against him as well as the range of punishment. His name is spelled correctly and he has to be set on the pretrial docket.
All right, the court finds Mr. Mitchell having waived the formal requirements of arraignment versus plea of not guilty to the record. Court sets Mr. Mitchell then for pretrial. You want to do October 30th, Mr. Manning? That's the evidentiary docket, but or do you want to do the 16th?
Judge, if we can do the 30th, I think this, based on my preliminary conversations with Mr. Mitchell, this may involve a little more discovery review on my part.
All right, court sets Mr. Mitchell then for pretrial October 30th at 1.
Thank you, Judge. It's fine. Next.
Who's next, Mr. Manning?
Judge, next I believe we're ready on Mr. Shoemaker.
Christopher Reagan Shoemaker, CR 23-74.
Judge, I believe you should have.
Shoemaker set for plea today. Mr. Shoemaker, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
All right, thank you. You can lower your hand. All right, Mr. Shoemaker. Are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
All right, and it appears that you were before this court on July 11th of 2023. On that date, you pled guilty to a third-degree felony offense of evading arrest or detention with a vehicle. The court heard the evidence and your plea agreement. The court approved your plea agreement, placed you on 5 years of deferred community supervision, and ordered you to pay a $2,000 fine. On May 20th, 2025, the state filed its motion to adjudicate and revoke. And in that motion, they have alleged 10 allegations of violations. Have you had enough time to review that motion with your attorney, Jonathan Manning?
Yes, sir.
And are you pleased with Mr. Manning and the work that he's done as your attorney?
Yes, sir.
Do you have any questions about your plea agreement here today?
No, sir.
And I see that the agreement is upon you pleading true, the state's recommending that your guilt be adjudicated. That means that you be convicted of that offense of evading arrest or detention with a vehicle, that your community supervision be revoked, and that your punishment be assessed at 4 years confinement in prison. And Mr. Manning, how much time is Mr. Shoemaker entitled to on credit?
Judge, we've agreed with the state that he has 114 days credit.
And you would receive 114 days credit toward 4 year sentence.
Judge, I may have miswritten, I may have mistyped that out. Give me just one second, Judge. I'm sorry, Judge. That's 244 days credit.
That's just a few more days, isn't it, Mr. Shoemaker? That's just a few more days than
Just a couple,
114.
sir.
Just a couple, just a couple. Well, I'm glad you were there to nudge him and say, hang on, I need my couple days. Okay. All right. So understanding that is your plea agreement, Mr. Reagan, I'm going to ask you at this time, how do you plead to counts 1 through 10? Are all counts true or not true?
True.
And all counts being true, you're pleading to true because they are in fact true, correct? You're not just
Yes,
telling me
sir.
that to get a plea agreement. Okay. And Mr. Shoemaker, has anyone threatened you, forced you, or pressured you to plead true to any counts here today?
No, sir.
Mr. Manning, do you believe Mr. Shoemaker to be competent to enter into this plea agreement? And
I do, Judge.
if so, and have you explained to him his rights regarding the case?
I have, Judge. He understands his rights and is waiving those intentionally, knowingly, and voluntarily.
All right, the court does accept the defendant's plea of true to each count as alleged and admits the defendant's waiver of waiver of rights and plea of true into evidence. Mr. Manning, anything further?
Rest in peace, Judge.
Anything further from the state, Mr. Hartwell?
Nothing further, Your Honor. Thank you.
All right, then based on the judicial confession and the evidence before the court finds that Christopher Reagan Shoemaker has violated the terms and conditions of his community supervision. Court follows the plea agreement today, revokes the community supervision of Mr. Shoemaker, adjudicates his guilt, convicts him of evading arrest and detention with a vehicle, assesses punishment today at 4 years confinement in Texas Department of Criminal Justice, orders him to pay the balance of his financial obligations, and awards him 244 days credit towards his sentence for the time that he has spent in jail on this cause. Mr. Shoemaker, once you're released from TDC, if you've not paid off your fines, court costs, and fees, you're ordered to report to the Van Zandt County Courthouse to make payment arrangements. Failure to do so could result in a warrant being issued for your arrest. Do you understand?
Yes, sir.
All right. Thank you, sir. I'm going to have you step over to be fingerprinted. Go ahead and bring your next client up, Mr. Manning.
Judge, next we'll be ready on Mr. Joseph Parks.
This is cause number CR 22-192, State of Texas versus Joseph Leon Parks. Mr. Parks, sir, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thanks, sir. You can lower your hand. All right, Mr. Parks, you were before the court previously on July 5th of 2022. On that day, you pled guilty to the state jail felony offense of unauthorized use of a vehicle. I believe that offense was then, the punishment range was increased and your punishment was assessed at 10 years confinement. Well, that can't be, that's not legally correct. The motion says that punishment was assessed at 10 years confinement in the state jail division of TDC, but that's not the case. Go back and look at your judgment.
I got probation.
Oh, yeah, what are you talking about? What's going on?
Motion.
You're fine. Say yeah. Do that.
Okay.
Mr. Manning, what was the original sentence assessed in this case?
Judge, I believe when I pulled it up, they had sentenced him to 10 years probation, and it was on a state jail, but there was not a plea of true to the enhancements at that time.
Okay. All right, let me have Mr. Parks have a seat. Let me recall his case. Let me go back and look at the original sentence.
Yes, Judge. Yeah, stand there.
Do you have anyone else that's ready?
Yes, Judge. Mr. Wilcox.
This is cause number CR 25-57, State of Texas versus Colby Wilcox. Mr. Wilcox, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can lower your hand. Give me just a moment while I look at your paperwork. All right, Mr. Wilcox, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with the work that he's done for you?
More than please.
Do you have any questions about your paperwork that contains your plea agreement?
Sir.
Mr. Manning, do you believe Mr. Wilcox to be competent? And if so, have you explained to him his rights regarding his case?
I do, Judge.
All right,
And I have explained the rights.
Mr. Wilcox, you are charged with a third-degree felony offense of unlawful possession of a firearm by a felon, a third-degree felony that does carry a range of punishment of not less than 2 years in prison, not more than 10 years in prison. I see the plea agreement in your case is states recommending 3 years confinement in prison, along with a $1,500 fine and forfeiture of the weapon seized in this matter. Mr. Manning, how much credit time would Mr. Wilcox be entitled to?
Judge, I show that by agreement, we have 209 days credit.
209? So what you said, 209, 209?
Judge, yes, Judge, but my client has a question. Let me check with them real quick. So. That's it. Is there anything else besides that? Yeah. Yes, Judge, 209 days credit.
Okay, so Mr. Wilcox, towards that sentence of 3 years, you would receive 209 days credit towards your sentence. In addition, the plea agreement would require that you pay court costs of $290 and reimbursement fees of $120. Is that your agreement here today, Mr. Wilcox?
Yes, sir. That's right. Sir. Yes, sir.
Okay, and so at this time, Mr. Wilcox, I would ask you, how do you plead to unlawful possession of firearm by a felon?
Guilty.
Are you pleading guilty of that crime because you are guilty of committing that crime?
Sir.
Has anyone threatened, forced, or pressured you to plead guilty?
No, sir.
All right, court does accept the defendant's plea of guilt. Mr. Manning, any objection to the evidence?
No objection as offered.
The evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
From the defense?
Rest in close, Judge.
All right, court will review the evidence. All right, the court, having reviewed the evidence, finds enough evidence to convict the defendant. The court will follow the plea agreement. The court convicts Colby Darnell Wilcox, defendant, of third-degree felony unlawful possession of firearm by a felon, assesses punishment pursuant to the plea agreement at 3 years confinement in the Texas Department of Criminal Justice, orders him to pay a fine of $1,500, court cost of $290, and reimbursement fees of $120. Further, the court does forfeit the weapon seized in this matter, which is laid out in the special findings of the judgment. Mr. Wilcox, once you're released from TDC, if you've not paid off your financial obligations, you're ordered to report to the Van Zandt County Courthouse so you can make payment arrangements to pay off your fines, court costs, fees. Failure to do so could result in a warrant being issued for your arrest. Do you understand?
Yes, sir.
All right, thank you, sir. I'm gonna have you step over to be fingerprinted.
Thank you.
All right, Mr. Manning, if you would go ahead and meet your next client.
Yes, Judge.
All right, Mr. Manning, who do you have?
Judge, this is Mr. Warrington.
This is cause number CR 25-138, State of Texas versus William Gerald Warrington. And we're set for plea today. Mr. Warrington, sir, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
Thanks, sir. You can lower your hand.
Thank you.
All right, Mr. Your name is William Gerald. Is it Warrington or Warrington?
Warrington.
Warrington. And Mr. Warrington, in this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning and the work that he's done?
Of course, yes, sir.
Are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Ever been diagnosed with a mental condition?
No, sir.
All right, I see that there is a plea agreement in your case. You are charged with a second-degree felony offense of possession of a controlled substance. Wherein in the indictment, there are enhancement paragraphs. What would normally be a third degree would become a second degree for punishment purposes if the allegation is found to be true or pled true to. Court finds that the range of punishment for a second degree felony is confinement not less than 2 years in prison and not more than 20 years in prison, and also a fine not to exceed $10,000. In your case here, it appears upon you pleading guilty to the offense and pleading true to the enhancement paragraph that the recommendation from the DA's office is that your punishment be assessed today at 10 years confinement in prison. But they're recommending to the court that that sentence be suspended today and that you be placed on community supervision for a period of 5 years. And that you would also be responsible in order to pay $1,500 in fines, $180 in restitution, $540 in reimbursement fees, and $290 in court costs. Mr. Warrington, is that your understanding of the plea agreement?
Yes, sir.
All right, Mr. Warrington, then understanding the range of punishment and the plea agreement, how do you plead to possession of a controlled substance in penalty group 1 greater than 1 gram, less than 4 grams?
True. Guilty.
Guilty? And are
Yes,
you
sir.
pleading guilty because you are guilty of committing that crime?
Yes, sir.
Now I'm going to ask you, with regards to the enhancement paragraph allegation in your indictment, is that allegation true or not true about your previous conviction?
Yes, sir. True.
True. And has anybody threatened you, forced you, or pressured you to either plead guilty or plead true?
No, sir.
All right, the court does accept the defendant's plea of guilt and plea of true. Mr. Manning, any objection to the evidence?
No objection as offered.
All right, the evidence is admitted. Court does take judicial notice of the defendant's pleas. Anything further from the state?
Nothing further, Your Honor. Thank you.
From the defense?
Rest and close, Judge.
All right, court will review the evidence. All right, the court, having reviewed the evidence, finds enough evidence to convict the defendant of the offense. The court of the state follows the plea agreement. The court convicts William Gerald Warrington of possession of a controlled substance in penalty group 1 greater than 1 gram, less than 4 grams. Court finds that the enhancement paragraph is true and that elevates the degree of the offense to a second degree felony. The court follows the plea agreement in assessing punishment at 10 years confinement in the Texas Department of Criminal Justice Institutional Division. And the court suspends that sentence and places Mr. Warrington on 5 years community supervision, orders him to pay a $1,500 fine, restitution in the amount of $180, and court cost of $290, reimbursement fees of $540. And the court does find the enhancement paragraph to be true. All right, Mr. Warrington, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm going to have you step over to be fingerprinted. After that, you'll meet with the probation officers.
Yes, sir. Thank you much, Judge. Thank you, man.
You're welcome. Go ahead and get your next client.
Judge, at this point, I just got the paperwork for my final plea, and I've just got the second round of clients. So if I may have a short period of time to get that paperwork done, we should
Yes,
be able
sir.
to rock and roll.
Yes,
Thank
sir.
you,
Go
Judge.
ahead. Mhm.
Your Honor,
That's the name of the, that's the name of the reason. No, the.
I keep-
And, they found that you. It's very nice individual. Joy Fallon, very 25 of life. They still have the full range punishment. Yes. Yes, so you have most waiting for 10 years. So 10 years per day. $5,000 fine. That's safety. Those are trying to do probation.
Your Honor,
Mr. Manning, you ready?
Yes, Judge.
Who you ready on?
Judge, let's start with Mr. Templeton.
Right, this is cause number CR 25-115, 116, State versus Stephen Marcus Templeton for pretrial. Go ahead.
Yes, Judge. At this point, we have no contested pretrial issues. We request to be set on docket call. Additionally, Judge, my client would request a offer on his case, as he would like to get back to TUC.
All right, court sets Mr. Templeton for docket call October 16th at 1:30. Mr. Hartwell, if the state is going to make an offer, I ask that you make that to Mr. Templeton with him to have enough time to consider it prior to the 16th.
Judge, next I'm ready on Mr. Junior Spence.
Mr. Spence, if you'll make your way up, this is cause number CR 25-103, State
Honor.
versus Junior Lee Spence.
I'm sorry, before we continue, offer was sent out on Mr. Templeton a while ago. It's 7 years and $2,000.
7 years TDC.
Oh. Judge, he'll take that. If we can, I just had the paperwork ready on the 16th.
Okay, and you said that was 7 years TDC. Did you say a fine, Mr. Hartwell?
Yes, $2,000 fine, Your Honor.
2,000. Okay, thank you, sir. Appreciate it.
And which would that be in CR 25-115 or 116?
That is on. I think I left it up to Mr. Templeton to choose.
Debating it. Actually, it's out.
And that's fine, Mr. Manning. I'll let y'all talk about that later. I want to go ahead and move
Yes,
on.
Judge.
Spence, and we've got him set to the 16th.
Yes, Judge.
Mr. Spence, come on up. Mr. Spence is set for pretrial. Go ahead.
Judge, at this time, there's no contested pretrial issues. We request to be set on docket call announcement.
All right, court sets Mr. Spence for docket call October 16th at 1:30.
I didn't have this covered. Good job.
Your Honor, I apologize. Zoom kicked me out for about the last 30 seconds, so I missed everything on that.
Mr. Spence didn't have any contested pretrial motions. We set it for docket call 1016, and that was it.
Thank you, sir.
Mr. Manning, your next time.
Judge, next ready on Patrick Richardson.
Paul Richardson,
Patrick.
Richardson. Oh, there's two. You got Patrick and Paul. All right, Patrick Lee Richardson, CR 25-186 for arraignment. Go ahead.
Yes, Judge, and I apologize. I had pulled up the indictment to go over with him, but it for some reason logged off. So give me just 1 second. I'll pull it up again.
I can get it for you too, if that helps.
I got it, Judge.
Okay.
So they charge you with a third-degree felony continuous, starting from an offense of 30 to 5 here in Passaic County. This individual saying that on or about April 19th, 2025, you intentionally on robbery injury, two assaults. So for this one within the whole month. Not even to this case, but just go over that. I'll leave it this Friday. Next Friday. Is your name spelled correctly? Okay. Your Honor, Mr. Richardson's name is spelled correctly. He understands the charge against him as well as the range of punishment. His plea is not guilty, and he requests to be set on the pretrial docket.
Court enters the not guilty plea for Mr. Patrick Lee Richardson and finds that he's waived the formal requirements of arraignment Court sets pretrial October 16th at 1:30.
Thank you, Judge. I have not seen him yet, but I will. Talk about it.
Who's next?
Judge, next ready on Paul Richardson.
Paul Rodney Richardson, CR 25171.
Judge, we have no contested pretrial issues at this time. A request to be set on the docket call setting. Judge, just to let you know, there was an issue with some of the evidence. I wasn't able to locate that in the other case, but I was unable to locate an offer. So if the state has an offer, if I could get that before our next setting.
All right, court enters docket call for Mr. Did you hang on, let me back up real quick. You said that there was an issue with the discovery?
Judge, I was unable, when I went over the discovery with Mr. Richardson here at the jail, we were missing a couple of videos from the Canton Police Department. I was able to locate those in an unfiled case that had been provided discovery to, and so I was able to view those videos in the unfiled case.
Okay. Court sets Mr. Richardson then for docket call October 16th.
Stuff, yeah. That is fire. Same.
Who's next?
Judge, believe Mr. Odell is next.
Vincent Everett Odell, CR 25170.
And Judge, unfortunately, I have not had the opportunity to go over the discovery of Mr. Odell's case with him. I requested an additional pretrial to review the discovery and prepare for his case.
No
We just
objection, Your Honor.
Thank you, Mr. Odell. We just got him back from Hutchins, right? He's in
Judge, all I know is when I was looking at my notes, I saw that I had not had an opportunity to go over this stuff with him. So
oh no, I'm sorry. I was looking at Mr. Park's case. Okay.
okay.
All right. There being no objection, the court grants that request, sets additional pretrial October 16th at 1:30.
And state, do you show that we have an offer in that case?
I don't show that I've done any work in the case, so I don't know for sure. I can try and locate one and get with you later on that though.
Great, thanks so much.
Who's next?
Judge, next we can do Mr. Jackson.
Right, this is cause number CR 21-361, State versus Jaquavian Antron Jackson. Motion to revoke. Go ahead.
Yes, Judge. I believe that we're going to get this case resolved if we could set it for the evidentiary hearing on September 30th.
All right, court sets Mr. Jackson for contested hearing September 30th at 1:30.
I'm sorry, Your Honor, was that September 30th?
Yes, September. All right, Mr. Manning, who's next?
Judge, Mr. Walter Baird.
State of Texas versus Walter Lynn Baird, CR 25-153 and 164. Mr. Baird is set for pre-trial. Go ahead, Mr. Manning.
Judge, I have had an opportunity to go over some of the discovery with Mr. Baird. However, there's some additional items that I need to discuss with him. If I may have additional pretrial on his case, that would be appreciated.
No objection.
Thank you, Mr. Harwell. All right, court will reset Mr. Baird's cases for pre-trial to, do you need more time than the 16th, Mr. Manning?
Judge, we did get through quite a bit of it in our last setting. So I think just because he is in custody, if we may have the 16th, that should keep things on track.
Okay, that you want the 16th?
Yes, Judge.
All right, court will set Mr. Baird then for October 16th at 1:30.
Yeah, but anything else? I'm gonna let this Friday.
All right, who's next?
Judge, I was just informed that Mr. Clardy, Billy Clardy, is refusing to come up. This is my first setting with Mr. Clardy, and at this point in time, I don't have discovery or an offer as to his case.
Why is he refusing to, is it a mental health issue?
They said he was angry and said we weren't gonna do anything, so he wasn't coming.
Tell Mr. Clardy that he is due in this court, and if he doesn't voluntarily walk up here and take part, I will have him restrained and brought up here.
Yes,
So
sir.
that we can arraign him and talk about his cases.
And Judge, Mr. Jeremy Cunningham was my client last setting. He explained to me last setting that he was wanting to hire someone and has hired someone. Justin King filed a motion to substitute. I believe that was filed earlier this week, and I was made aware of that by his copying me on that.
You said he did file a motion to sub?
That's correct, Judge.
Okay, I haven't seen that. Generally, I would see that. Let me look. Did you see a file stamped copy of that?
I don't believe so. I just saw where I'm sorry, it was sent yesterday. And it was just a letter of representation. There was not a motion to sub.
Okay, I do see a letter of representation, so Mr. King needs to file a motion to sub counsel since you've already been appointed by the court. So
And Judge,
go ahead, I'm gonna reset this, but then you just need to, I can have Mr. Abraham notify Mr. Cunningham that a letter of rep's not gonna work, that he'll just need the motion to sub, and then I can grant that before the next hearing. What were you gonna say?
Judge, I was gonna tell you I could reach out to Mr. King if you'd like, but if Mr. Abraham would like to do that, that's fine.
It would be best if both of you did it, I think.
Okay, I will reach out to him this afternoon.
All right, so today is the 18th. We're gonna reset it to September 30th. That's a Tuesday. I anticipate you won't need to be here, Mr. Manning, so I'm gonna set it on Tuesday, the 30th.
Yes, Judge. Right there. Right there. That's where it's supposed to sign. Sure.
Your Honor,
Yes, ma'am.
Mr. Clardy, they said is on suicide watch. They're trying to get him up here, but they've also had a medical emergency.
So he's on suicide watch because he's got a mental health issue? Is that what you're telling me? You're telling me that he's not coming up here, not because he's angry, but he's not coming up here because he's on suicide watch and he's got a mental health issue?
The first deputy told me he was angry and was not coming up. When I asked now, I'm told that or Sergeant Martinez told me they told him he was on suicide watch. And they've had a medical emergency also, so they're all back there with that.
Judge, if you'd like, I can go to Mr. Clardy's cell and see if I can speak to him. Like I said, this was my first appearance with him on this case. So if you'd like, I can try to go talk to him and see what the deal is.
I don't want you to have to do that. Let's let jail staff deal with the medical emergency. And if that takes care, if it subsides, then let's get a more definitive answer. I don't like getting he's angry and he's not coming and then being told that he's on suicide watch. So I need definitive answers from the jail staff so I can make the right decision.
Your Honor, just try to talk to him. Come in here. He wants to fight. He's not going to come no matter what, unless we bring him by force.
But is he on suicide watch because he's
Yes,
got a
sir.
mental health issue?
They just have him on suicide watch. I can go ask further. He wants to kill himself. He wants to die. Whatever you want.
Okay. Well, that sounds like a mental health issue to me. And how difficult would it be to restrain him and bring him up?
There's 5 of us ready to do it. You just say the word.
Mr. Manning, your client?
Judge, at this point in time, I'd asked that we file a competency evaluation. Sounds like he's not in his right mind.
Well, I don't want to do that yet. I don't think we have enough to do that yet. But I'm saying, do you want to go talk to him first, or do you want me to have him brought to you?
Judge, I'll go talk to him.
Okay.
Would you like to
Mr.
do that
Manning,
now?
do you have anyone else that's ready?
I have the plea paperwork should be done on Martinson. It should be in your queue. And then I have a couple females that will need to be reset as well.
Let's give Mr. Clardy time to cool down a little bit. Let's go ahead and go through the other ones.
Okay.
And I'm also ready. We can circle back on Mr. Parks as well. So
Okay.
whoever you want next.
Judge, let's do. Are we going to proceed with Mr. Parks' plea, or are we going to need to reset him?
Yes. Yeah, we can proceed.
Okay. Yes.
All right, we're back on the record. CR 22-192, State of Texas versus Joseph Leon Parks. Just 1 second here.
And Judge, I think one cause for concern, just for clarity's sake, is that in looking at the judgment for this case resolution today for the probation violation, I don't see that there's ever been made a finding of true on the repeat felon offender. And so I don't know if that's a problem for the court or not. Like I said, I just got the paperwork just a little while ago, and looking over that's one issue that I saw pop up.
Yeah, I agree with you. So what I was going to do in full transparency is I was going to admonish him today and ask him for his plea on that. And I think that will rectify the issue, because it appears that the plea agreement at the time did contemplate that he would be prosecuted for a 2nd-degree felony, in parentheses, repeat felony offender, which brings into play that enhancement paragraph. So that was how I was going to treat it.
Okay.
Are y'all comfortable with that?
Judge, we're ready to proceed.
All right, Mr. Parks, did I place you under oath in our last setting?
Yes,
I
sir.
did today. Okay. All right. So, Mr. Parks, let's begin by talking about your previous judgment. I'm going to go ahead and display this on the screen for you so that you understand what we're talking about.
Okay.
Can you see that, Mr. Parks?
Yes, sir.
All right, so this is your, what we call the underlying judgment or your first judgment. This is where you were convicted by the court on July 5th of 22 and accepted the plea agreement for 10 years confinement in the Texas Department of Criminal Justice that was suspended, and you were placed on probation for 10 years, received a fine, safety as a condition of community supervision. And you can see there where it says degree of offense was second degree felony, repeat felony offender. What's missing in this judgment that should be there, that appears to be part of your agreement, was there should have been a enhancement paragraph noted on the first enhancement paragraph. There should be a finding on that first enhancement paragraph. Let me go and let me see if I can pull up your.
Your Honor, I believe since the underlying was a state jail, there should have been a finding on both enhancement paragraphs. Yes, sir.
Let me see if this was in Brooks notice, or let me see if it's in the indictment. I'm not sure. Okay, so there's in fact, it's called paragraph 1, but there's actually 2 paragraphs. So here in your indictment, Mr. Parks, this first paragraph is the primary charge in which you were accused and pled guilty of unauthorized use of a motor vehicle. Then you'll see this enhancement paragraph 1. Directly following that are 2 paragraphs, both containing allegations of your prior convictions, one in Wood County in 2008 for escape from custody from a penal institution. The other was in 2012, also in Wood County, for the felony offense of unlawful possession of firearm by felon. When we did your plea back in 2000,
Judge,
I guess.
Judge, if I may, we were unable to see what specifically the court was referencing in that indictment.
Oh, you don't see the indictment right now?
No, Judge.
Oh, okay. Sorry. What about now?
There it is, Judge. Guess what he's
Okay.
talking about is body of the paragraph up there. Then you have an enhancement paragraph. So that had 2 paragraphs separated out that one. Yeah.
So, Mr. Parks, what I'd like to ask you today, what I should have asked you back in 2022 or 23, I guess, whenever we did this, was these enhancement paragraphs. Are these allegations true or not true?
That's true.
They're true. And you're telling me today that they're true, and you're not being forced, pressured, or threatened to plead true to these allegations that were part of your plea agreement and the underlying cause.
No, they're true.
Okay. So today, it appears that your plea agreement, you were placed on probation in that case. And since then, the state has filed on November 14th of 23, they filed a motion to revoke your community supervision that was granted previously. And in that motion, they've alleged 3 allegations that they say are violations of your community supervision. Have you had enough time to review that with your attorney, Mr. Manning?
Yes, sir.
And are you pleased with Mr. Manning and the work that he's done?
Yes, sir.
Mr. Manning, does your client intend to plead true to all 3 counts?
Yes, Judge. I believe it's just one violated, or one condition has been violated. That is condition A.
Okay, but he's pleaded true to the 3 separate counts.
Judge, if I apologize, we had discussed this at our last setting, but I believe that he only pled to one of those new offenses. If I may just have a moment.
Go ahead.
Thank you, Rich.
Judge, I believe that was just the evading arrest out of Hunt County.
So you're saying, so he's only pleading true to which count?
Evading arrest, motor
I
vehicle.
believe it's count 1. I apologize. Give me just one moment.
Here's the motion. Count 1 is he looks like he evading.
Yes, Judge.
In Hunt County. Count 2 is looks like obstruction. Count 3 is UUMB.
Yes, Judge. He was only found guilty of the count one.
Okay. All right, and so, Mr. Parks, at this time, how do you plead to count one in the state's motion to revoke? Is that count true or not true?
That's true.
And you're pleading true because in fact you are responsible, you're legally responsible for committing that conduct that's outlined in count one, that you did then and there intentionally flee from Deputy Burns.
Yes, sir.
Okay. And I see that there is a plea agreement here, Mr. Parks. Upon you pleading true, the state's recommending that your community supervision be revoked, that your sentence be assessed at punishment at 2 years confinement in TDC, and you'd be ordered to pay the balance of your financial obligations, which includes a $1,500 fine, $290 in court cost, and $140 in reimbursement fees. You would be entitled to some jail time credit. And how much is that, Mr. Manning?
Judge, we were able to confirm that between the original date of offense of 122 days and his subsequent hold since February 6th of 2024, he has a total of 712 days total.
712 days. All right, and so Mr. Parks, you would receive 712 days credit towards your sentence in that plea agreement. All right, the court takes judicial notice of Mr. Parks' plea of true. Court admits into evidence the defendant's plea of true and waiver of rights. Court finds that Joseph Leon Parks has violated the terms and conditions of his community supervision. Court follows the plea agreement today, finds that he has violated count one of the state's motion to revoke. The court revokes the community supervision, assesses punishment at 2 years confinement in the Texas Department of Criminal Justice, and orders him to pay the balance of his financial obligations, and awards him 712 days credit towards his prison sentence for the time that he's already spent in jail on this cause. Mr. Parks, you're hereby remanded to the custody of the sheriff so you can carry out the terms and conditions of the sentence. When you do get out of TDC, I need you to report back here to the courthouse so that you can make arrangements to pay your court costs and fines. Failure to do so could result in a warrant being issued.
Yes, sir.
Mr. Hartwell, I think we should do, based on our testimony from Mr. Parks today, if you will send me a nunk on that original charge with a finding on the pleas of true.
Yes.
And that way we don't get any kind of response from TDC that they're, think that we've sent them down there on a second degree and they don't have the punishment enhancements.
Yes, sir, will do.
It's either that or we somehow reflect it on our deferred judgment. Just 1 second here. Let me finish, Mr. Jones. All right, Mr. Manning, who's next?
This is Mr. Martinson, and he is also going to be doing a plea today. I was going to ask you earlier, shut the phone.
All right, this is cause numbers CR 25-50 and CR 25-51, State of Texas versus Stephen Martinson. Mr. Martinson, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. You can lower your hand. All right, Mr. Martinson, your name is Stephen Martinson, is that correct?
Yes, sir.
Mr. Martinson, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you are represented by your attorney, Mr. Jonathan Manning. Are you pleased with the work that he's done?
Yes, sir.
Do you have any questions about the paperwork that you've read and signed?
No, sir.
Mr. Manning, do you believe Mr. Martinson to be competent to enter into an agreement? If so, have you advised him of his rights, including the advantages and disadvantages of a deferred adjudication plea?
Yes, Judge. I have had many opportunities both at my office and here in the jail this week to discuss this case with Mr. Martinson. I believe he's entering into this plea intentionally, knowingly, and voluntarily. Additionally, Judge, I have explained to him the positives and negatives of a deferred adjudication, particularly with the element of safe P being a condition of his probation. I walked him through what was necessary to complete safe P, not just in the program itself, but also to complete the aftercare program in order to be successful, not only with this probation, but with conquering his addiction.
Thank you, Mr. Manning. Mr. Martinson, in cause number CR 25-50, you're charged by indictment with a third-degree felony offense of assault of a family or household member by impeding breath or circulation. That does carry a range of punishment of not less than 2 years. Well, let me ask here. I see it says third-degree felony, then it says RFO. What is the range of punishment here? Is this a third degree enhanced to a second? 'Cause I
Judge, this
see
is I'm sorry, Your Honor. This is
It's
a
okay.
third degree. We did file a Brooks notice today as a part of the plea agreement that has 2 prior felony convictions, making it a 25 to life HFO.
HFO. Okay. Is the judgment correct then where it says degree of offense, third degree RFO?
Not if it says RFO, Your Honor. It should say HFO. I
Well,
believe
will it say-
on the enhancement paragraphs, Judge, on the judgment, it lists both enhancement paragraphs as being pled true and found true by the court.
Right, yeah. Should the degree of offense change to a first degree? Or does it stay third degree and then enhance to HFO? Sometimes I'm
believe it
not sure
stays-
how. Third
Yeah.
degree?
I believe it stays third degree enhanced, yes.
Okay,
But it should say HFO instead of
HFO.
RFO.
okay. So we can either,
I can have another judgment sent through via electronic signature in just a couple minutes, Judge.
yeah, the only problem with that though is it all stays together as one e-file. So
Okay.
we'd have to sign everything. What we could do is I could just make a finding on the record today and then we could knock it
Okay,
later.
that'll be fine.
Mr. Manning, are you comfortable with that?
Judge, I mean, we fully recognize the range of punishment when we took the plea, and additionally, as the court and Ms. Curry noted, on the enhancement paragraphs, both of those are pled true, and we were provided notice of the enhancement paragraph by the Brooks notice that was filed today.
But are you okay with signing a judgment today that says RFO, repeat felony offender, and doing a nunc pro tunc later that says HFO? So that the
If I may ask my client real quick. And then it's back. Where's my best bet on that? Right. Okay. So delayed. So I had just said, go with this. It's not happened. Just look at it. So I'm not pro. Fix them. Oh, I changed it to that one. won't change anything else. So that one.
So still be put on probation today and then I'll be put in for bail here in 3 weeks.
Yes, that's correct.
So you're saying, I mean,
That.
that sounds good.
Judge, I've spoken to Mr. Martinson and he is fine with proceeding today as the paperwork says, the RFO, and then having that portion amended to a nunc-pro-tunc at a later date to show HFO instead.
Thank you, Mr. Manning. Thank you, Mr. Martinson. Okay.
And Judge, I'm sorry, Your Honor, while we're on that, I'd like to orally move to amend the Brooks notice. I believe the first enhancement paragraph in the Brooks notice says that the conviction was in Rio Blanco County, Texas. It's actually Rio Blanco County, Colorado.
And Judge, that is correct. We pointed that out to the state. It is correct in the stipulation of evidence. It is correctly listed as him pleading true to being previously convicted in Rio Blanco, Colorado, and we are unopposed to a interlineation by the court on that paragraph.
Okay, the court does grant then, without objection, the state's oral motion to amend the Brooks notice in this matter. All right, so Mr. Martinson, let's kind of start over here a little bit just for clarity. So your third degree, you were originally charged with a third degree felony offense of assault of a family or household member by impeding breath or circulation. And that typically would carry a range of punishment of not less than 2 years and not more than 10 years in prison. However, the state has alleged in a notice filed that you have prior criminal history that, if found to be true, would increase the punishment range of your offense from a third degree to what is known as a habitual felony offender, which changes the range of punishment from that minimum 2 to a minimum 25, that maximum of 10 to a maximum of 99 years or life. So I see that the plea agreement today is that you would be pleading guilty to that offense. You would be pleading true to each one of your prior enhancements, prior allegations, in exchange for the state's recommendation that the court consider the evidence, not convict you, for the court to place you on 10 years of community supervision, along with a $2,500 fine and placement in the SafeP rehab program as a part of your community supervision. And then the state would also be asking the court to allow it to dismiss CR 2551, which is another assault charge. In addition to that, you would have court costs of $290 and reimbursements of $535. And you understand, Mr. Martinson, should the court approve this agreement and you violate any of the terms and conditions of your community supervision, the state could file a motion to bring you back to court. They could ask the court to hold a hearing, and if they prove to the court that you violated any of your conditions of community supervision, they could ask the court to do several things, including revoking your community supervision, convicting you of the offense, and assessing your punishment anywhere from that minimum 25 years in prison to that maximum 99 years or life in prison. Do you fully understand and appreciate the risk associated with this type of plea?
Yes, sir.
Okay, and understanding all that, you still wish to go forward?
I'm fully confident I can do this.
Okay, Mr. Martinson, how do you plead to the third degree felony offense, assault of a family or household member by impeding breath or circulation?
It's just guilty.
Are you pleading guilty to that crime because you are guilty of that crime?
Yes, sir.
Mr. Martinson, how do you plead to enhancement paragraphs 1 and 2? Are the allegations contained in those enhancement paragraphs true or not true?
True, sir.
And you're telling me both enhancement 1 and enhancement 2 are both true, correct?
Yes, sir.
Mr. Martinson, has anyone threatened, forced, or pressured you to plead guilty to the charge or plead true to your prior enhancement allegations?
No, sir.
All right, then the court does accept the defendant's plea of guilt and the defendant's pleas of true. Mr. Manning, any objection to the evidence?
No objection as offered, other than the things that we previously pointed out regarding the judgment.
All right, the evidence is admitted and the court does take judicial notice. The court will note that the court will at a later time correct for a clerical mistake the RFO to include HFO for a habitual felony offender, and the granting of the state's oral motion to amend its Brooks notice. Ms. Curry, anything further from the state?
Your Honor, I'd just like to say that normally, as I'm sure the court knows, we don't enter into a deferred agreement with someone that has the criminal history that Mr. Martinson has. However, there were two things that influenced us. The first is that his last criminal history was in 2004, slightly more than 20 years ago. But more importantly, Judge, we're doing this at the request of the victim in the cause. And so that is the reason for the unusual nature of this plea agreement.
Thank you, Ms. Curry. I do appreciate that. Anything further from the defense, Mr. Manning?
Judge, I just point out that while I explained the substantial risk to taking a deferred plea with Mr. Martinson's type of history, he was insistent that he does need drug help, as that is what's led to him having this case in the first place, as well as him being here in jail instead of being on bond at this time. And so, Judge, when he said with confidence that he believes he can do this, I think that he is motivated, and I think that his 20 years of being clean and sober prior to this offense demonstrate that he can, with the right tools, maintain a level of living in society and as a productive member. And so we ask that you accept this plea.
Thank you, Mr. Manning. Court will review the evidence at this time. All right, the court, having reviewed the evidence, finds enough evidence to convict the defendant of the offense. The court will follow the plea agreement and recommendation today. The court defers the finding of guilt for Stephen Martinson on assault for family or household member by impeding breath or circulation, a third-degree felony. The court finds that enhancement paragraphs have been alleged against the defendant, to which the defendant has pled true. The court finds each enhancement paragraph to be true. Court finds that upon that finding, the punishment range is then increased under state law to habitual felony offender. However, the court will not impose sentence today. It defers a finding of guilt and places Mr. Martinson on 10 years community supervision, orders him to pay a $2,500 fine, orders him to pay court costs of $290, reimbursement fees of $535. And the court also orders Mr. Martinson to attend Safe P as a condition of community supervision. So, Mr. Martinson, it seems as though you are in a position to where you owe a debt of gratitude to first and foremost Ms. Stringer, who has asked the DA's office to extend this to you, and then to Ms. Curry in her office for then extending this to you.
And I do.
Otherwise,
Thank you.
you're welcome.
And I do. Thank you.
And so part of the way that you can repay that debt of gratitude, Mr. Martinson, is by showing Ms. Curry and Ms. Stringer that you're going to go down to safety and that you are going to take advantage of getting clean and getting back to society and repaying your debt. That's how you begin. Okay.
Yes, sir.
So you've got a huge anvil hanging over your head in a 25 to 99 years or life sentence in prison. Minimum 25 years for this type of offense. You're probably going to do 20 if you end up in prison, just based on what about pardon and parole. How old are you right now?
53.
That may be a life sentence for you. That may be a death sentence for you. You understand
Yes,
that?
sir. I do.
I cannot stress the importance of the opportunity that you have here. It's really a life or death opportunity, and it's in your hands. So I hope you see it and take advantage of it. All right, Mr. Martinson, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm gonna have you step over to be fingerprinted, and then probation will give you more information if they haven't already.
Yes, sir. Take care of it. Yeah, we take care of it administratively through the clerk's office. Okay. Yep. Thank you.
Your Honor,
Yes, ma'am.
As far as next week's trial goes, Judge, I believe that after Mr. Schmidt filed that motion to withdraw, I looked at two other cases that might be easy to get ready quick, one of which was Mr. English, who waived jury today. The other was Mr. Martinson. It's my understanding from Ms. Tabraham that the court is going to cancel the jury for next week. Is that correct?
Yes, ma'am, and I already have.
All right, thank you.
Yeah, I was gonna let you know, but yeah, I went ahead and canceled it over lunch because you and I were on the same page.
Okay, thank you,
Alright.
Judge.
You're welcome. Mr. Manning, anyone else?
Yes, Judge, I have Miss Nix.
This is cause number CR 25-127, State of Texas versus Caitlin Shira Nix, and we're set for pretrial.
Yes, Judge. At this time, we have no contested pretrial issues. We request to be set on the docket call announcement for this case.
All right, court will set Ms. Nix then for docket call October 16th at 1:30.
So. As soon as I ask your name, I'll come visit you. As soon as I ask your name, I'll come visit you, okay? Judge, next I have Miss Harvey.
All right, this is cause number CR 25-132, State of Texas versus Dorothy Louise Harvey. Ms. Harvey is set for pretrial.
Yes, Judge. We have no contested pretrial issue at this time. We request to be set for docket call. At my last check this morning, I did not have an offer for Miss Harvey. I know that Mr. Hartwell and I need to sit down and discuss her case to hammer something out, but we would request that we go ahead and move forward as she is in custody, move forward in docket call.
All right, court will set Ms. Harvey then for docket call October 16th. And Mr. Hartwell, if you haven't made an offer, if you'll just, and if you intend to do so, then just make it prior to the 16th so she has time to consider it.
Yes, Your Honor. I'm sure once we hammer those issues out, we'll get to one the same day.
Yes, sir, I understand.
Thank you.
All right, Mr. Manning, did you have a chance to see Mr. Clardy?
He's on his way.
Judge, I just learned that apparently he's on his way.
Okay, good.
Great choice.
And Judge, just a heads up, because I don't have access to discovery at this point in time for Mr. Clardy's case, if we could have the indictment pulled up to go over.
Yes. We'll go ahead and do that now.
There's two of them.
Yes, sir.
I'm not gonna go. I think I'm gonna step out of the way. Sorry, you're talking with someone, John. I said there's 5 of them bringing it. I think I'm gonna step out the way. Would leave. Oh, sorry. My bad.
Yours. I don't want to say nothing, ain't nothing to say. I don't have nothing to say. I don't have nothing to say.
Well, I've got plenty to say to you, Mr. Clardy. Have a seat, or you're going to find yourself in contempt of court, and you're going to have a longer sentence. Mr. Clardy, have a seat. Mr. Clardy, you're going to have a seat, or I'm going to direct these officers to seat you. And if we got to go get a restraint chair, okay, officers, go ahead and get your restraint chair and bring him in. We're going to restrain him because he's not suffering from mental health.
All I have to do is walk in and walk out. I ain't got nothing to say.
Let's put him in a restraint chair and we'll silence him. He doesn't have to say anything, but he needs to be here to listen. So you're either going to sit down in that chair and be quiet and listen, or I'm going to go get them to get a restraint chair. You're going to be gagged, you're going to be restrained, you're going to be seated, and you're going to listen. See, I knew that you were a rational guy. I knew that you would listen.
Can we hurry this up?
Excuse me? Did you know, Mr. Clardy, we could have been done 30 minutes ago if we didn't have to put up with you. We could have been way done. You're the one that's slowing this down. Your cooperation is only going to help you. It doesn't help me. You understand? Mr. Clardy, we're set today on arraignments for criminal allegations, CR 25-181, CR 25-189. You've been charged with possession of a controlled substance, a third-degree felony, and unlawful possession of identifying information. To your right is Mr. Jonathan Manning. He's the attorney that I've appointed to represent you because you said you're indigent. You're not able to afford one to represent you. Mr. Manning, I'm going to go ahead and display the indictments for you so that you can advise Mr. Clardy of what the range of punishment is and make sure that he understands the nature of the allegations.
Yes, Judge.
And Mr. Manning, I may have to do them one at a time. So just tell me when you're ready for the next one.
Thank you, Judge.
Can you
Mr.
see
Clardy,
181?
Yes, Judge. Mr. Clardy, is your name spelled correctly? And do you understand that you've been charged with a second-degree felony, which has a range of punishment of 2 years up to 20 years in the Texas Department of Criminal Justice?
You ready for the next one, Mr. Manning?
Yes, Judge. And Mr. Clardy, your name, I showed that your name is spelled the same way as the previous one. Is this case has also been enhanced to a second degree felony, which has the same range of punishment. And to both these charges, Judge, we're going to enter a plea of not guilty and request to be set on the pretrial docket. Additionally, Judge, we would request discovery if that's not been provided to us at this time.
All right, the court finds that Mr. Clardy, failing to answer the questions of counsel, has waived the formal requirements of arraignment. He's been advised as to what he's been charged with, including the range of punishment. The court will enter a plea of not guilty as a default for Mr. Clardy, and the court will set Mr. Clardy for docket call. I'm going to set this one a little further out. Mr. Manning, seems like you're going to have a lot more to deal with. This will be October 30th.
And Judge, you said docket call, but
I'm sorry,
yes.
pretrial.
Thank you,
Pretrial, October 30th.
28.
No, we'll do the 30th for Thursday.
Thank you, Judge. Just have me here.
And Your Honor, for the record, discovery was released earlier today, but while Mr. Manning's been at the jail, so he hasn't had a chance to see that it's come through yet.
All right.
Thank you.
Mr. Clardy, next time we have court, I expect you to be dressed in here, ready to go. Thank you, jail staff. I do appreciate you.
Judge, I believe that concludes my business. May I be excused?
Yes, thank you, Mr. Manning. And don't you love your job?
Yeah, I am well compensated for it, Judge.
All right. So I want to say thank you to jail staff. Thank you, Ms. Abraham, Sergeant Martinez, Mr. Hernandez, Ms. Curry, Mr. Hartwell, Mr. Schmidt, everyone that got our jail docket done today in a timely manner. Do appreciate you. We are adjourned.
Thanks, Your Honor.
You're welcome.